jump ahead to number 8, because I think this is very interesting. It's interesting in the Republican debate. It's interesting to see what happened in Australia and in the United States. Topic or segment number 8 is executive presidency versus the Westminster system of responsible government. If anything distinguishes the American from the system in the realms, in the United Kingdom, Australia, Canada, New Zealand, and the like, is having an executive president, contrasted with the Westminster system. One person as the executive in the United States, in the other countries, Australia and so on, a collective executive, in effect, which is responsible to the lower house. It's relevant to recall that when the Americans were developing their convention, their constitution at the Philadelphia Convention, Hamilton, Alexander Hamilton, it was really the lead person in the development of the Constitution. Having written in the Federalist Papers, he was one of the 3 writers of the Federalist Papers, which are still worth well reading. There's a lot of political wisdom in the Federalist Papers. If you go to the Federalist Papers, you'll see that he argues strongly against a collective executive. There were suggestions that the new executive of the United States should be, for example, a 3-person executive. I don't think anybody suggested a consulate of 2, as in ancient Rome, but they may well have. He argues strongly for what he saw as the British model, although the founders condemned George for his breaches of the fundamental rights of Englishmen. They said they were at the time of independence, they said the fundamental rights of Englishmen were being usurped by the king. He was breaking the agreement to maintain those rights. But what Hamilton argued for was the most effective form of executive government, he said, and that is the single-person executive. Now, the very interesting thing is if you mine through the conventions in Australia, and there were 2 conventions, the one in 1891 and the subsequent one about 1896, those 2 conventions, you only find one suggestion that we should go down the American path, and that was by Sir George Grey, who was a delegate from New Zealand, because the first convention was an Australasian convention. It involved the New Zealanders because they were thought of as a potential state. But there's still a provision in the Constitution for the New Zealanders to join our federation if they were so stupid as to do that. But they weren't. At the 1891 convention, Sir George Grey tried to argue that the clause relating to the Governor-General should be so vague, an elective Governor-General would develop. In other words, he was looking forward to the development of effectively an American-style republic. And so Samuel Griffiths, who was our first Chief Justice, he'd been the Premier of Queensland. The dominant force at the convention argues very strongly against this. And he says that experience shows that it is better to have the government sitting in Parliament, and it's better to have a single executive because he, subsequently she, must take responsibility for the actions of the government. It's particularly in emergencies, it's better to have one person as the executive rather than spreading the executive as we do over many. And if you look at the American system, you'll see how different the legislative program is. In Australia, about 99.9% of legislation comes from the government. Private bills are introduced, but they never get anywhere unless either it's done as a front for the government, or it's in an area where politicians are uncomfortable to have a party position, such as abortion for with the Liberal Party and the National Party. Usually most legislation comes from the government. In America it's completely different. And that's developed some very interesting legislation. So, John, do you think in retrospect, what do you think of Sir George Grey's proposal that we should have eventually an elective Governor-General?
Well, a couple of points on that. First of all, I think that one of the brilliant aspects of a constitutional monarchy is that the Governor-General is above politics. And there's a continuity expressed between governments, which is not the case in the United States. You might find interesting to know, you probably as a constitutional scholar probably do know this, but that first 10 years of American history, governed under the Articles of Confederation, there was no executive. There was a single body, and each state was represented, and each state got, the 13 colonies within states, got one vote. And that's how they were governed, without an executive.
Does that explain Hamilton's wish to have one person?
Well, yeah, as you know, there was a lot of debates. There was one making George Washington king. There was put forward all kinds of different proposals, and I think what they came up with is, unfortunately, I think they're in my view, it's lacking in that stability that we have in a Governor-General. And I think particularly with the reserved powers that are vested by the Constitution in the Governor-General and not in the Queen, in the Sovereign. So why Sir Samuel Griffith argued that, I don't know for sure. But I do think that it's the right move to have a constitutional monarchy and a Governor-General who is appointed by the government of the day. Or recommended by the government of the day, I should say.
The founders did make other mistakes. I think they were probably right in this regard. It would have been an extraordinary experiment to have an elective Governor-General, although some countries, for example, the Parliament in Papua New Guinea actually elects by resolution they appoint the Governor-General, or they appoint the person who's going to be recommended as the Queen as Governor-General. But I think they did make some very significant mistakes, and before I invite some of the young ambassadors to come up and ask questions or make comments, if they wish, their mistakes were firstly to trust the High Court with reserved powers. The American Constitution in the 10th Amendment, those amendments were passed, as you know, at the time the convention, the Constitution was going through, so that all states could join. There were a number of states who would not have joined but for the first 10 amendments. And one of them, the 10th, was that all powers not set out, not granted to the federal government, would be reserved to the states and the people. And our High Court worked under that assumption. They called it the Reserved Powers Doctrine. As soon as the original judges of the High Court gradually disappeared and new ones were appointed, under the influence of Sir Isaac Isaacs. Sir Isaac Isaacs had been a delegate to the Constitutional Convention in the 1890s. He tried to make Australia a highly centralised federation with vast powers as the central government. As you know, he became our first Australian-born Governor-General. So Isaac Isaac didn't have his way at the convention because the convention didn't want that. But when he got onto the High Court, he was very encouraging to getting rid of the reserved powers doctrine, the assumption that the Commonwealth only had those powers set out being granted to the Commonwealth. And in a case in 1921 called the Engineers case, a young KC, not a QC, a KC, because they were King's Counsel, a brilliant young KC, Robert Menzies, who became Prime Minister, argued the case. He argued an innovative case. To do that, to argue something that goes against precedent, you have to advise the court in advance and ask leave to present that. He asked leave, and he very quickly got leave, particularly from Sir Isaac Isaacs. he got leave to argue against the reserve powers doctrine, which narrowed the Commonwealth's powers. And after that, they argued that the powers set out to the Commonwealth should be interpreted broadly in accordance with plain English. In other words, this allowed the High Court to begin a long period of expanding Commonwealth powers so that they reduced state powers significantly. An extraordinary development. Had the founders had the wisdom to put that into the Constitution, that would have changed it. There was another error they made, that it was making the Senate always half the size of the House. So when Bob Hawke decided we needed many more politicians, instead of having 6 senators, which is more than enough because you only have 2 in America, having 6 senators per state, we now have 12 senators per state. That was an obvious mistake. The other mistake was to leave the appointment of the High Court just to the federal government. Now, if you want judges who are inclined to centralist attitudes in relation to Commonwealth powers in the High Court, let the High Court choose those judges. And I think the final mistake was in relation to the referendum. The only body that can propose a change to the Constitution is the federal parliament, or it's never happened, one house of the federal parliament. Otherwise, a change to the Constitution can't be made. There should be some way, and there is in the American Constitution, some way for the states to be able to propose changes to the Constitution, say a majority of states or something like that, because that is wrong. That is wrong to leave it to federal politicians who are obviously interested in increasing the powers of the federal parliament. The other thing that was wrong, I think, was to not even to listen to, because he wasn't able to argue it, the Premier of South Australia, who came to Canberra with a proposal to introduce some form of direct democracy into Australia. He would have been open to a proposal that the people also, as in Switzerland, the people also be able to propose changes to the Constitution. We can't do that. The states can't do that. Only federal politicians can. That's why so many of them have been rejected, because almost all of them have been to increase the powers of the federal parliament. Most of them are no longer necessary because the High Court has done the job for the federal politicians, which is to be predicted with the benefit of hindsight if you appoint judges only by the federal government.